All cell phones are to be turned off and put away, please. No exceptions. All rise. Butler County Common Pleas Court is now in session. The Honorable Judge Daniel Hoy presiding.
Please be seated. All right, we are here for the purpose of arraignment, State of Ohio versus John Allen Carter, case number CR 2023-030345. On behalf of the state and the defendant. All right.
Do you want us to read our identities into the record, Your Honor?
I think appearances would be helpful.
Certainly.
Mike Moser, Butler County Prosecuting Attorney. Brad Burris, First Assistant Chief Trial Counsel, Butler County Prosecutor's Office. Katie Pride, more Senior Litigator, Butler County Assistant Prosecutor, Butler County Prosecutor's Office.
Thank you, Mr. Moser.
You're welcome.
Morning, Judge.
Morning,
Chris
Pagan.
Pagan on behalf of the defendant, John Carter, who sits to my right, and behind me are two co-counsels, Lawrence Hawkins and Jacob Long.
Very good, thank you. Mr. Pagan, has Mr. Carter been served with a copy of the indictment?
He has, and for the court's benefit, he's 34 years old. He has been served. We'd waive a reading, we'd waive the 24-hour period, and enter a plea of not guilty at this time.
Very good. Court will note the not guilty plea. I know there'd been some discussion apparently amongst counsel about a potential pretrial date. And I know that I have the defendant's motion for bond in front of the court today. Do we want to address the date, the scheduling first?
I'd like to do that because I think it concerns the defense more than the prosecutor. We've met with the family consistently since the indictment. After yesterday, I have every reason to believe that we'll have a signed fee agreement by the end of the week. But out of caution, what I would like to do is set it for Tuesday to inform the court of our progress on that, to make certain that we're in. And my office, once the clerk's office is up and going today, they're having some problems electronically. Once it's up and going, we're going to file for discovery. That will toll time. And we'll file for a bill of information, and we can address that next Tuesday. And I think the state agrees with that, but I'll let them speak for themselves on the issue.
We have no objection to coming back for a pretrial next Tuesday at the court's leisure.
Very good.
I have a conflict on Tuesday, but my staff will be present.
So we're looking at April 4th.
I'm ready Thursday. This Thursday. Tuesday.
Are we wanting to do that on docket, or do we want to set a morning setting?
Whatever pleases the court.
Whatever pleases the court.
We'll set the matter for April 4th on the 1 o'clock criminal docket. We will miss you there, Mr. Moser.
Thank you, Your Honor. Nice to be missed.
I know, we'll just suffer, Mr. Burris. It's no suffering to have the pride more there.
Thank you.
I think it's just a question of whether or not counsel for the defense is in or the counsel is not in.
I appreciate that, so we'll be nice to have that answer on the date that has been suggested. As to bond,
We filed a written bond submission. I'll rely on that. There's just a few things that I'd want to highlight. We say in the bond motion that there aren't bond factors that cut against release. I believe that to be true. I'd like the court to consider the fact that my client not only has a constitutional right to bail, but to a reasonable one. It's my view that if he was made to be a pretrial detainee in this case, that it would obstruct his ability to present a vigorous defense, and it would cut against the presumption of innocence that he has here, especially given the fact that the law on bond and the bond factors so heavily sway in his favor. I point out that there are conditions available to the court, GPS, curfews, pretrial services that are available. We welcome them, and he will comply with those conditions. And I'd ask the court to consider its options in setting the bond to permit a 10% bond, a property bond, or a surety bond, and give the family all of those options in order to meet the bond being set. Thank you.
Thank you, Mr. Fagan. From the state?
Yes, Your Honor. Thank you. Please, court.
Counsel.
Your Honor, the defense has invoked Rule 46, and I would ask the court to consider Rule 46C, subsection 2, which goes to the weight of evidence. Because this procedure has now invoked that aspect, I think it's incumbent upon me to bring to the court's attention certain details that would normally be provided in the course of discovery as opposed to an issue of bond. So in that regard, Your Honor, I offer to the court several documents that were received shortly before this matter went to the grand jury for consideration, which resulted in a probable cause determination of an indictment for murder. Murder with respect to 2 counts, not 2 individuals. Purposeful murder and felony murder, as those are described in the murder section. I ask the court to consider documents that were received pursuant to a search warrant prior to that indictment, shortly before. Those documents were found in a folder identified as being and belonging to Mr. Carter, the defendant. They were sandwiched in a number of documents, some with his name on them printed above the material, others not, but nevertheless found at a residence where he had once resided, along with a door with printing on that door, above that door, that has particular significance. In this case, I will assert to the court for this consideration, as well as a forensic anthropology report, which indicates that there was sharp instrumental trauma to a wrist bone of the decedent under examination by a forensic anthropologist, which will be submitted to the court. The first document, which I'll give copies immediately to the defense so that they can follow with me. Reads as follows. Deep down, I love her. You want to kill her. But I love her. She must die. I can't kill her. Yes, you can. No. Yes. How do you talk me into all these things? I'm just that good. But you're bad. I know. How do I kill you? You can't. You're right. About what? Nothing. Item number 2, Your Honor, above the door of the defendant's residence. I slit your wrist with the key to your heart. The forensic anthropology report.
I did give you a copy of that, did I not, John?
Not yet, perhaps. On page 4 of that report, there was a set of 3 or 4
sharp force wounds to the left wrist of the distal end of the right radius. I slit your wrist with the key to your heart, showing once again the dichotomy, the struggle, the demon within, it would be asserted, between the defendant and himself. One voice saying, "Why should I kill you?" and the other saying, "You must." Words to that effect. Paraphrasing, of course, what I just read to the court. But it doesn't end there. Again, to that issue, I sit in my place, clenching my fist, while you sit there and tell me to slit my wrists. I wouldn't do it if I had the chance, but I look up at you to get a glance. You look at me trying to kill, and you don't because you're not real, and I know you won't. But you used to care, and you used to be great, but now when I see you, you're full of hate. So I get up to touch you, and you disappear. You left. You were gone. And now I have nothing to fear. So I jump for joy into the next room and look to my left, and you're back so soon. So I run back to the kitchen and into my place, telling you to leave before I rip off your face. I'm sorry I said that, but now you see I have been going crazy and insane because you're mad at me. Above that is the name John A. Carter associated with this document. And lastly, Your Honor, going to the weight and sufficiency with respect to what's going on in this defendant who's asking to be released on bond into our society by John A. Carter. Shut up, you're driving me crazy. I don't like you. No, I hate. No, I can't stand you. Get away from the phone. You're so much a little bitch. I'll say when you can talk. Quiet, I have no room to talk. Get out of my house and never come back. Never come back. You hear me? Oh no, what have I done? What do I do? I know I'll bury the body in the backyard. No, I'll bury it under the trailer and wait until the grass grows over it and leave before anyone reports it missing. Yes, yay. That's a great idea. The evidence in this case is well known to the court, to the public, to everybody in this county and probably this country, because this is a high-profile case with respect to the media. That the body was found years after the person disappeared in a bag at a location 30 miles from her residence. This body was meant to disappear and never to be found. Perhaps to disappear under a trailer with the grass growing over it. But as the forensic report says, the place where the body was ultimately found is probably not where the body was first deposited. And that's in the forensic report. The bones were removed from where they were, beginning to decompose there, and later decomposed at the location. All of this will be in discovery, certainly submitted to this court at this time. As an exhibit in this presentation with respect to the issue of bond, which we're asking to be set with respect to a charge of murder at $1 million. Thank you, Your Honor.
Thank you, Mr. Moser.
If I could just be heard in response, of course, it's unfair to be able to respond to presentations of evidence when we get them not received. But I direct the court to two things. One is the bond factor that Mr. Mosier points out is an appropriate bond factor, but it asks you to weigh the weight of the evidence. And I don't think a presentation here permits that. And in a cursory review of the report from the anthropologist, I see that it was dated 6/18/2013, which was 9 years ago, which I think has some significance to it.
Well, Your Honor, I'd briefly respond. You can't consider the weight of evidence pursuant to this rule unless you have some idea of what the evidence is. For me to stand and blindly say to the court with empty words of, take my word for it, Judge, the weight's really strong, we really have a great case, but I can't show you anything, makes no sense. I thank the defense for giving me the opportunity to show them what they're getting into. I thank the court for its consideration of this issue, because ultimately the decision is yours to make. And whatever your decision is, I'll live with it without criticism. Thank you.
Well, I'm not going to criticize the notion that I find it a very unusual bond factor for a judge to consider the weight of the evidence when the evidence is not in a position to be presented, aside from what was presented here today or in any other bond hearing for that matter. I'll say an unusual factor. The court also, of course, has to consider the nature and the circumstances of the crime charged, which, as the state points out, it's an unclassified felony, a murder charge, 2 murder charges. The defense points out, also appropriately, with respect to factor C4, that the defendant has significant family ties, employment, that his length of residence in this community, that his lack of any serious criminal record also points to a willingness on his part to be here. So there is a factor that weighs in the defendant's favor, that being that C4 factor. However, the nature and the circumstances of the crime charged, the nature of this charge, and albeit, I'll call it a preview or a piece of the evidence that the state intends to offer, being offered here today appropriately to give the court the notion of the weight of the evidence against the defendant, also cut in favor of the state's request. The court has, as it does with every case, I've had pretrial services conduct an investigation, and the court notes that the recommendations here also echoing what was stated in the defendant's bond motion with respect to Mr. Carter's residence, his employment, and his treatment. The court certainly thinks it's appropriate to set a bond. With respect to the bond the court deems appropriate in this matter, that bond will be the sum of $1 million. With respect to the utilization of cash, surety, or property in any methodology, it is appropriate. Additional obligations of that bond are reporting on a weekly basis to Butler County Pretrial Services, as well as a GPS monitor. The only restriction, as recommended by Pretrial Services, is that there be no contact with the alleged victim's family. And to be clear, I don't believe there's been any suggestion that there's been any inappropriate contact, that the court would adopt that as a condition of the bond. Counsel, anything further for the record today?
Nothing on behalf of the state, but our thanks.
Just so I think I understand, but I want to clarify, it's a 10% surety or property bond, or any mix of those, at $1 million with the conditions that you've prescribed.
it's cash surety or property. I did not authorize the posting of a 10% bond.
Thank you, Your Honor.
That'll be the order of the court.
Thank you, Judge.
Judge.
All rise.
Thank you, sir. As they say, as in a fire.
So let's,
Then we go back.
It's the bottom.
yeah, for a moment. We need to talk, Teresa.
Sure. Let's do it.